so much for watching Law School Made Easy at Law School Made Easy 256. We want to first thank you so much for liking our channel, subscribing, sharing our videos. Please continue sharing our videos. And today we want to look at contract law 2, and particularly want to look at one of the vitiating factors, one of the factors that vitiate a contract, and that is duress. We want to appreciate the concept of duress. What do we mean by duress? What amounts to duress? What are some of the elements that different judges at common law have discussed that would amount to duress? And to discuss that with me is Sheila Bogele Counsel. Thank you so much for joining us. May you say hello, greet the viewers of Law School Made Easy.
Thank you so much, Counsel Walter. I'm really glad for the opportunity of being here with the viewers of Law School Made Easy.
Thank you so much. Welcome, and we thank you for honoring our invitation. We pray that you continue to come and teach the world about the different concepts of the law. And today, Counsel, we want you to take us through this concept of duress. Like, when we come across it as lawyers, as students, what comes to our mind? How are we supposed to handle this concept of duress?
I think the first line that a student should put down is consent obtained through coercion. If there is no free will, then that may be construed as duress. So, yes?
Counsel, you're saying that if consent is obtained through coercion, that the party did not agree to it, then there is duress.
Yes. If there was compulsion, if you are induced to enter into this contract,
You are compelled.
you are compelled, you are untwisted, then definitely you can argue that there was duress and this contract will be actually voidable at the instance of the aggrieved party. So the lawmakers are actually interested in what was the procedure that led to the contract, the making of the
So
contract.
Counsel, in simple terms, are we discussing when a contract is done, or we are discussing before the formation of the contract? Earlier on, I had a discussion about discharge, and you see in discharge, a contract has been concluded, but then something comes out, or first something comes up and frustrates the contract. Now, what happens in lines of duress? Are we discussing after a contract has been made, or procedures to making a contract?
Oh, we are looking at a contract that has been made. What the interesting thing with contract law is, the first thing we study as students of law is that a contract is all binding. You know, you're bound by what is within the four corners of that paper. So at the end of the day, if a contract is made, you'd think that there is no wiggle room for this person, for the aggrieved party. But actually, if a contract is made under compulsion, then that person can say, okay, during when we are discussing, when we are agreeing to this contract, there was actually a threat that was made to me. I can bring to you the case of Barton versus Armstrong. And in this case, there was threat of violence. It's a common law position. If somebody threatens to bring you bodily harm, threatens murder, yeah, and then you end up being induced
Loss
into
of
a
life.
contract, loss of life, then certainly we are going to see that as duress, and the courts may provide you some reprieve.
So, Counsel, you say that at common law, duress meant threat of violence.
Yes, but when you look at the Contracts Act, if you interest the members of Law School Made Easy, and they go to the Contracts Act and they read, they find out the definition of coercion.
In section 1.
In section 1, because you find that there is no definition that defines duress, but you can find it, you know, under coercion. And yeah, in common law, you'll see that it looked at if somebody is threatened, if there's that legitimate pressure, if somebody is induced, then they'll say there is duress. But then if we look at the Contracts Act, we'll look at instances of economic duress.
But Counsel, before we go to economic duress, I want to we request members to subscribe, to share, and continue liking our videos. But before we cross to economic dress, at common law, we can exhaust it. At common law, did they consider property or persons? Threats on person or property?
The one definitely threats on a person.
Persons,
You
yes.
say, okay, I entered this contract because there was a threat to my life. But then when we go to the standing of the contract law, was there even threat to property? Yeah, did somebody threaten to retain the property, to hold the property until you do something? Yes, you can still seek reprieve from the courts of law if that happens. And that could be under economic duress, which would lead to financial.
From our discussion,
loss.
it feels like duress at common law was limited. And I think some people, in terms of property, will not get a remedy, a serious remedy. So now, how have courts designed to ensure that they reach out to everybody? That in terms that, in case you are put under pressure to sign a contract, in terms of where we work from, in terms of our usual dealings with other people, what happens
Okay,
in that line?
there have been cases, to answer the question, I think I'll use cases to elaborate on the matter. If we look at the case of D&C Builders Limited versus Rees, and
D&C Builders Limited versus Rees.
yeah,
Rees, what's the spelling?
REES. And D in this case stands, I elaborate what D&C stands for because usually we say defendant and claimant, and people may think this is D, defendant
And the
but
claimant.
actually, but
Now
actually,
passing.
but actually it's Donaldson, and that was a decorator, and C stands for Casey, who was a plumber.
So D and C, D stands for Donaldson,
Yes.
and then he was a decorator.
Yes.
And then C, Cassie,
Yes.
who is
a plumber.
a plumber,
Yes.
Builders versus Rees.
So they did some work for Mr. and Mrs. Rees, and they suffered financial loss during this period of time. They were constrained financially.
Their company was
Their-
struggling.
Yes, and the Rees got to know about it. The two Rees got to know about it. So they decided to take advantage of them, to gain unfair ground on them, and said, you know what, we're going to give you less money. You take it or leave it, you know.
Is
But-
that duress really? Because from what we are discussing, if I give you a duty, an obligation, Sheila, you're supposed to do something for me, and as you do it, your company runs bankrupt, and then about it, I tell you, I reduce on the money I'm giving you.
If you look at the ingredients of this case, you look at it that they were meant to get maybe 480 pounds,
Yes.
and these people reduce it to 300 pounds. But they had done work worth 480. Now these people knew that, Rees knew that D&C were constrained, that they needed money badly, that they would say yes to even the scraps, to the crumbs coming off the table.
So they were
that
taking
commercial
advantage.
pressure, yes, was illegitimate. Yeah, of course I know there is where commercial pressure is lawful, and the courts will say no, that is okay. But in this case, it was really unfair.
Mrs. Rees was taking advantage of the situation.
Oh, yes.
That because already she had an obligation to pay the 480 pounds. Now that she hears they have a situation, she reduces the money and puts them on pressure, forcing them.
Yes.
Oh, so that's what courts have termed as economic pressure.
Yes, and of course we do not forget that it has to be unlawful. In this case, you have to appreciate that it was illegitimate. And what is interesting, a real contract was made where Rees made D&C to sign that we have accepted the 300 pounds, and you've completed
In
the
completion
payment.
of all payments.
Yes, so that is how it seemed like. But the courts looked at this contract and said, no, it is voidable. Even if it has been made, it is actually voidable.
So we have discussed different factors
Yes.
that vitiate a contract, and among them is misrepresentation. And in misrepresentation, you find that it makes a contract voidable. Then you have said that even duress, a contract becomes voidable. So before we continue, can you clarify for us what is void and voidable for our students?
A void contract is one that is, we usually say, void ab initio, from the get-go. You know, when you look at the factors that led to the creation of this contract, really they were obsolete.
The constellation is illegal,
and
everything is illegal about it.
yes, and that one,
For example, a contract to go and kill Alvin.
it has no legs to stand on. But when you come to a voidable contract,
Voidable, yes.
that one can stand if you do not protest against it. Yeah, if you do not bring it to the attention of the courts, and you allow the whatever to go on, the status quo to continue, then certainly that is a voidable contract. It stands until the aggrieved party says no. Please look into it.
Either you affirm it or you run out of it.
Yes.
So it is at your discretion.
Yes.
You, the person who was
Who's
induced
claiming
into the
to
contract.
be disadvantaged.
We
Yes.
thank you so much.
Yeah.
We thank you so much, Pastor Sheda, one for honoring your invitation and for the wonderful discussion we are having. But we are urging members to subscribe, share, and like our videos. It's gospel made easy. Let us now understand more this concept of duress. Now, in the event that I was induced by duress, I started duress, and I entered into a contract, and my consent was obtained falsely, and I just move on. I don't protest. I just go. I spend 3 years, then I come back, I claim.
When you said that, it brings me to another case. That's a locus classicus. That is how
What do you mean by locus classicus? For
you can use other words like leading case, landmark case, that it influenced. Yeah, it influenced the decisions in other cases.
That's a locus classicus.
Yes, it has a pivotal role when it comes
That's
to
what we are
discussing
explaining it
duress.
for Alvin. He doesn't know locus classicus.
Yeah, you can use word like semano, and so forth to show.
Let us go to the case.
We go to the case. Oh, power on v
You long.
Long.
That's how I take it. You long.
Yes.
Power on versus be young.
Yes, these were major shareholders. They have companies, and if you look them up, I can even give you the companies. But they were major shareholders. So we look upon them, and we just pull them out of this whole entire situation. They were shareholders, and they each said, I'll sell to you my shares from this company, and then the other was like, oh, I'll sell to you my shares from this other company, and so forth. But then they had interest in why. So one of them was really using economic duress to get a contract to be signed. So when they went to the courts of law had to deliberate, was there economic duress or not? Because one party claimed that there was economic duress. And this is when we bring in the four tests that were suggested by Lord Sherman. He proceeded and said, if you want to decide which criteria to use to decide on whether there is duress, then you're going to look at a number of factors. Did the aggrieved party protest? That is one. Was there an alternative legal course available to that party? Was he independently advised? And then did he act promptly to see that this contract is set aside? So those are the tests that the courts of law use to decide whether there is economic duress or not. Yes. So the concept of duress is interesting in that there is legitimate commercial pressure and there is also illegitimate commercial pressure. So the courts have to decide on such, to deliberate on such, on a case by case. Because there is freedom of contract. That one here. Yeah, that we look at that each party has equal bargaining power, they have the freedom to contract, and courts usually don't want to interfere with contracts, but the courts also know that there can be unequal bargaining power and economic pressures that may induce disadvantaged parties, into agreeing to contracts that they would otherwise not agree to.
In power on versus being wrong, I'll say that the test that for you to be able to claim
Yes.
that there was economic duress, you must first show it you as the person who is claiming that it was there. One, you said by protesting. You must protest.
Yes.
You don't take so long, but you must protest. And then you said you must, if there is, what do you call it?
Alternative.
Knowledge, alternative
Yes.
legal advice.
Yes.
Okay.
Then
And
also independent advice.
Independent advice,
You got
yes.
independent advice, you may not be able to get
And then the
your
last one?
promptly. You must act promptly so that you set this contract aside. Otherwise, if you let it stand, then you have affirmed the contract, and therefore the courts will not be very indulgent.
So
of
if you
your
don't
claim.
come up, it means you have affirmed it.
Yes, you have affirmed.
Because you must show, no, this contract,
Yes.
there was a problem before you entered it.
And it should be set aside, and beg and pray to the courts that
When you
it is
keep
set
quiet is
aside.
one way of affirming it.
Yes, indeed.
We thank you so much, Council Chair, for this wonderful insight. This has been very wonderful. Thank you, and we pray that you continue coming. Now, finally, as we conclude with this, I want to find out from you, as we discuss the duress, does the element of fiduciary come in duress relationship?
A fiduciary relationship will play a bigger role under undue influence as a officiating factor. Yes, and I believe once the students address their minds to that, they'll find out.
Oh, that one works more in undue influence.
Undue influence.
Okay, thank you so much, Council. You have done us well. We thank you for accepting our invite. We pray that you continue coming and discuss and enjoy together as we teach the world about the concept of the law. Thank you so much, Alvin on camera. Thank you so much. Until next time, subscribe, share, like our videos.